The first thing I'll say, well, first let me introduce myself. I'm Bob Bullock. I'm Deputy Director for Operations for the Rockefeller Institute, and it's indeed a pleasure to welcome members of SAPA to the Rockefeller Institute. We are, for many of you who have been with us before, and those of you who have not, we are SUNY's public policy research arm. You know, when Paul called up several weeks ago and asked us to partner, it was a very easy decision because work on promoting awareness of the upcoming 2017 referendum on the notion of a constitutional convention currently dominates our public programming and our thinking. Through programs like this, which are now being held throughout New York State and will be over the next 2 years, it's our hope that we're going to be able to help in assembling a truly informed electorate going into the November 2017 vote. And as we consider this notion of a constitutional convention, you could not have selected a better presenter. For most of his career, your speaker has made the New York State Constitution a central part of his academic work and his public pronouncements. So prominent was his thinking, and I don't want to steal too much of Paul's thunder, but from 1993 to 1995, the late Governor Mario Cuomo named your speaker as research director for the New York State Constitution Revision Commission. From this experience, he went on to co-edit with Hank DeLay. Many of you remember Hank from the Cuomo administration, the Commission's papers published as Decision 97. That was one of our publications here at the Institute. And his work on the subject now continues and will soon be seen on a book of which he is co-editor with Peter Galey from Canisius College and Christopher Bobst, also from Buffalo, New York's Broken Constitution, the Governance Crisis, and the Path to Renewed Greatness, which is going to be out in the 2016 period, and it will be published by SUNY Press. As earlier referenced, today's program is one of the scores of programs that the Institute will be putting on statewide between now and 2017, perhaps later, depending upon the outcome of the vote. I'd like to acknowledge our partners, the Government Law Center at Albany Law School, the League of Women Voters of New York State, and the Siena Research Institute. And if you want to find out more information, please go to our website periodically, www.rockinst for RockefellerInstitute.org, and you'll be able to find out about upcoming presentations. And actually, right now, we're working on standing up our Constitutional Convention papers. A quick housekeeping note, we are videotaping this, and so the videotape actually will be up on the website. And if you'd like to draw the attention of friends of yours who could not be here today, please then just go ahead and refer them to the website, and also they'll be able to find out more information about the Constitutional Convention. And finally, I would like to acknowledge with applause Patty Cadret, Mike Cooper, and Joe Chamberlain of our staff who made today's efforts possible. And so a round of applause for them, too. And so now it's my great pleasure to turn it over to Paul Schatzoff for our official introduction. Thank you for coming.
Thanks, Bob. That sounded pretty official to me, so I'll keep this brief. I want to thank Bob also and Rockefeller Institute for being so receptive to allowing SAPA to have what I'd say is a kickoff event for educating the public and certainly those of us who are interested in public policy about the Constitutional Convention referendum and the implications of it. So I want to thank Bob for embracing it so enthusiastically. So thanks, Bob. Gerald Benjamin, how could you be involved in public policy in New York and not know who Jerry is? And so, as I said to him when I welcomed him as he entered the building, I said, Jerry, I'm not going to read your entire biography because what we do know about Jerry, to sort of sum it up, is that he is the go-to person, or certainly a go-to person, and I would characterize it as the go-to person in New York State who is a universally recognized expert on public policy and public administration. And his colleagues agreed with that because most recently they renamed the center at New Paltz, the Center of Research, Regional Engagement, and Outreach at SUNY New Paltz for Jerry, and it is now called the Benjamin Center. So that's terrific, and certainly well-deserved. But I need to ask Jerry a question. So there was an article, I don't know if you all saw it. It was in the Times Union probably about 6 weeks ago, maybe a little longer, when the center was renamed for Jerry. And there's a quote in here from Jerry. It says, one day the phone rings, I pick it up, and the voice says, Professor Benjamin, this is you, Carey. Benjamin said, recalling the first time a sitting governor called after reading one of Benjamin's critiques in a news article. Thinking it was a colleague's prank, Benjamin replied with some colorful language. There was a little bit of silence, and again he says, this is you, Carey, and Jerry said, then I knew who it really was. So my curiosity is, what was the colorful language that you... Anyway, I want to thank Jerry for making the trip from New Paltz on this rainy day, and without further delay or ado, I want to ask Jerry to come forward and lead this candid conversation. I also want to just remind people to please silence your cell phones, because otherwise your unique ring will be picked up on the videotape and may interfere with the equipment. So thank you.
Thanks for that kind introduction. I'll boulderize a little bit. I said, Shartuk, what the hell are you doing? That's fine. You can imagine the language wasn't exactly that. But Bob Bullock is a great center of energy for assuring that the people of New York will know about the choice they're asked to make when the Constitutional Convention referendum occurs. And it's extraordinary, his level of achievement and organizational ability, and I just wanted to acknowledge that. Regarding the renaming of the center, which I was a little bit reluctant at first, I found myself, some of you who read Mark Twain might remember the scene of Tom Sawyer in the back of the church in the balcony observing his own funeral. And there was a certain gratitude and comfort I took in being alive for the moment. One of my colleagues, who will remain unnamed, said, it's always good to get a warm handshake. After I came to understand what he said, I appreciated it. Today I'm going to talk. I'm very pleased to be here, and I've been a member of SAPA for many, many years. I don't know how many, but certainly at least 20 years. And I am insufficiently engaged in SAPA's activities, so I regard this as participating. And so I appreciate the opportunity. I also understand that this is a conversation. So I expect to engage with you at your discretion and choice. So I'm not going to run through the whole presentation and take questions. If your preference is to engage me as we go along, just raise your hand or indicate that you'd like to do that. I hope and expect you'll say your name, so we have that for the record, and some in the room who may not know who you are can know who's asking the question or making the comment. A final prefatory remark: I regard this as an extraordinarily important audience. And you may think that's simply pandering, but in fact, there is not a great constituency for good government in New York. There's a constituency for the interests of public employees, and there's a constituency for the interest of environmentalists, there's a constituency for the interest of business, there's a constituency for the interest of higher education, to name one of the very many interested groups or organizations in New York that makes claims upon public policy and the public fisc. And one reason that we have trouble getting good government in New York lately, to the degree we have trouble, and I think there's a broad view that we do, is that constituency is not forward and considered with the force that it might be able to bring to the conversation. And I think that professionals in government who spend a lot of time trying to deliver good government as leaders in departments and agencies and as elected leaders and leaders in appointed positions and so on are precisely the people we need to have understand the choice that we have to make with the Constitution Convention vote, why we're offered the choice, what the equities are, how they balance, and I hope come to a decision that leads them to advocate for an opportunity for pressing the reset button for New York government, I would call it. So I am not disinterested and dispassionate on this question, although the Rockefeller Institute is. That's the disclaimer, right? I've done that right, Bob? Okay. And so I'm not speaking for the Rockefeller Institute nor for the university. When I express something beyond the empirical or the evidentiary, describe the evidentiary base. So let's get started, and do not hesitate. I've been doing this a long time, and I know the magic words which are, I don't know, but I'll find out. Okay. So the topic is a Constitution Convention for New York, the process. I'm going to talk about the process, although the process is entirely intermixed with the substance. And the separation between the process and the process cannot be considered without the ideological predispositions of the various people who are observing it and making judgments about whether to allow it, support it going forward, or stop it from going forward, and so on. So this is a process-related discussion, constitutionally focused, but with some discussion of the politics and some discussion of the statutory dimensions of this as well. It is not a discussion of whether we need term limitation or tax limitation or more positive rights or less positive rights, although I'm happy to engage that conversation too. That's not my plan for today. I want to be relatively brief and I want to be relatively focused. So I'm suggesting that we stay on process questions. So on November 7th, 2017, New York Constitution will require this question to be asked on the ballot. At the general election, etc., shall there be a convention to revise the Constitution and amend the same? Now, the question is specified in the Constitution, and there's a good reason for that in the politics of the 19th century. But the fundamental reality is that the question is specified, and that's consequential, and we will see why as we proceed. There have been 146 state constitutions in force in the United States. Only 2 state constitutions currently in force were adopted prior to the U.S. Constitution. New York has had 4 constitutions. Some say 5 because they count 1938 as a separate constitution. I think 4 because 1938 is a revision of 1894. The fundamental point is that it's common to change state constitution as it is uncommon to change the words of the U.S. Constitution, add to them, or take words out. Not done, in fact. Some have been rendered obsolete, but it's common to adopt new constitutions in the states. It has been common, and constitutional conventions are common. So one thing we have, one confounding reality that we face is that when we talk about constitutional conventions, there's an immediate association of constitutional change with federal constitutional change, and great resistance to that. The documents are fundamentally different functionally and operationally, and there's a great history of constitutional change by formal revision and amendment at the state level. Important to remember, many of you I'm sure know that, but it's important to remember this distinction. The mandated referendum vote has certain embedded issues. First one is that the question is unlimited. So unlike in some states, Illinois being an example, we can't hold a convention that's limited to tending to one particular article of the Constitution. In New York, we have to, if we have a convention, effectively open the entire document. Now, I've talked to some smart lawyers about this because I would prefer not to have to open the entire document, because that makes the politics a lot harder. So in Illinois, you can have a convention only address the legislative article, for example, under its constitutional revisions. There's been some statutory interest in this in the New York State Legislature to have a convention with a limited agenda. The legislature cannot limit the agenda of a constitutional convention because it's subordinate to the convention. The convention is an agent of the people, the sovereign, to redesign the system. The system design includes the design of the legislature, the separation of powers, the judicial branch, and so on. So the subordinate body can't constrain the superordinate body in law. So we can't have a limited convention. that opens up lots of concerns among people who are fearful that something will be changed in the Constitution that they wish to have remain unchanged. New Yorkers are relatively unfamiliar with referenda. We are not an initiative and referendum state. So unlike in California, we might regard ourselves as blessed for that, in that characteristic. But the fact of the matter is that the politics of referenda are arcane for New York. Now, we do have referenda on state borrowing when we do full faith and credit borrowing, which is far less than other kinds of borrowing, as many of you know. And we do have referenda on constitutional amendments. As in a recent year, we had 8 separate constitutional amendments offered all at the same time. But the New York electorate is not commonly mobilized around referendum issues, as is the electorate in initiative and referendum state. So the politics become difficult. You know, explaining the importance of this vote or its consequence in the frame of people who prefer not to have a positive outcome, who prefer a negative outcome. One strategy is to ignore the choice. And I'll talk more about that, because that's a compelling and effective strategy. So mobilizing around a kind of choice that you're not used to making in an off year, where turnout is lower anyway, is a complicated proposition for advocates. So the timing in the off year for the vote, off years are generally, when I was elected a local official, I didn't think that the odd-numbered years were off years. I thought they were the on years. The term off year is commonly used for the odd-numbered years in politics, and the timing of the referendum is significant. I believe, if I've got my math right, we will have a New York City mayoral election in that year, so that would have some impact on the turnout in downstate. There will be a number of county executive elections. Upstate people tend to vote at higher rates than downstate people in off-year elections. Normatively, we've published on that. But the turnout and the relative turnout in the state will be significant. Second, the timing, some people pay attention when they study politics to the political cycles, and we talk a lot about legislators wanting to take credit for outcomes in 2-year cycles because they're elected in 2-year cycles. So the time perspective of politicians is defined by the election cycle. And we have longer terms and shorter terms, longer terms for judges for certain reasons and so on. Well, here we have a 20-year cycle with quite an unpredictable context when the actual vote occurs. So the convergence or divergence between the vote and the need for the perceived need for change is an interesting problem, and it's largely serendipitous. You know, if we get the vote when people are really mad about something and some unnamed federal prosecutor keeps locking up elected officials, there might be one immediate set of stimuli. If we have a relatively quiet period where things seem to be going reasonably well, we'll have a different set of stimuli. And this is rather unpredictable. This long cycle, this 20-year cycle, creates a rather unpredictable context for this vote. So in 1977, for example, we were still negotiating the fiscal crisis, New York City fiscal crisis, and the attendant state difficulties, as many of you will remember that. And the leadership of the legislature said, oh, we're pretty worn out from dealing with crises. We don't need one more thing to worry about. And so there was this lowballing of the opportunity. And there was by the way, no preparation. And the failure to prepare is part of the formula for the failure to get a positive outcome. So this question of the cycle, or the automatic cycle, and when the vote occurs and what the context will be is important. This is from this week's Siena Poll, partner in our effort to communicate to the public about the Constitutional Convention. More than 70% say they have heard nothing at all about the 2017 vote. Now it'll be 69.999% after this meeting. And while support for the convention remains very strong, it is down from July. Now, I think these movements are kind of random because it's such a low visibility matter. But what I see in this is that New Yorkers think something's wrong and would like to do something about it. They're not sure whether this opportunity that's going to be, what this opportunity presented to them is. You know, there's this predisposition to be welcoming. Now, I remember in '97 when I was campaigning in favor of a convention, and I like to say 1 million people in New York agreed with me, but unfortunately 2 million disagreed. And the politics of that, we've written about that, and the politics about that are I could talk about. It's not today's topic. But we had the same going in poll results. So these are very, very shallow outcomes and very vulnerable outcomes. So, but the important thing is that we're measuring. You know, so the fact that we're measuring is significant, and the fact that you're measuring communicates, pay attention, because you're measuring, the outcomes are reported. There's puzzlement, why do people not know about it and yet favor it, and that generates conversation. So that's a good thing, in my opinion. Why do we have this vote? Well, in 1846, at a New York Constitutional Convention, delegates decided that there should be a way to go around the people in power to change the Constitution if the people in power are disinclined to change it, because they were potentially beneficiaries of the pathology that people, that others, the beneficiaries of the practice that others thought of as a pathology. So this is our path around the legislature and around the governor to change the fundamental document if we choose to do so. Almost every state has such a path. The national constitution has a path around the national government. You could change the national constitution entirely by state action. It's not a path that has popular referendum. Some people have sought that without success, and probably not a bad thing, but there is a path. Now, in other states, the path might be the constitutional initiative. In Florida, the path is a constitutional commission that's automatically convened and has direct ballot access with its recommendations. It's a unique provision. Actually, there are 2 constitutional commissions in the Florida Constitution, one for fiscal matters and one for other matters. And it's not untethered. The appointing authorities are multiple and in the state government, but in fact, it has an autonomous access to the ballot. So we have this method. There are other methods. 14 states have the method that we have. Some are states that have sought to emulate, like Hawaii was a late adopter of this idea. So we're returning to the sovereign people if we need to do so. And this enters us into democratic theory, which all of you, I'm sure, have quite familiar with. But the concept of the sovereign people and the creation of governments and so on takes a good deal of energy to communicate to undergraduates. But I'll assume that we're all good with this idea. Now, the convention is a blunt instrument, and that's scary. So one of my favorite stories, and I have to watch out for time, and somebody should ask a question and stop me from talking, which would be entirely welcome and positive, probably. But anyway, I was standing outside my synagogue after Rosh Hashanah, some of you, one of the Jewish high holidays in New Paltz. Our synagogue is a modest building in the center of the village, and the president of the union local for our school district walked up to me. He's a member of the synagogue, and walked up to me. He said, "Why do you want to take my pension?" And I said, "I have 2 things to say to you. I don't want to take your pension, and I don't want to talk to you about this now." But that was the fear that teachers had about opening up the Constitution, that contractually guaranteed pensions would be challenged. Other fears, that the civil service system would be challenged. that the Forever Wild provision would be undone. And there are numerous dimensions of the Constitution that are meaningful for numerous constituencies, as I pointed out, and their risk-benefit calculation suggests to them too risky relative to the benefit, because the benefit is very broad, so-called what I would call good government. And there's some skepticism about whether that benefit can be achieved. But the risk is very defined. And so risk-benefit, self-interest, is a compelling consideration. Yes, please say your name.
Stan Winter.
Right.
Given what things that you just said, what makes you think or feel that this Constitutional Convention would have any more, if it is indeed held, would be any more successful than 1977, which was the greatest fiscal boondoggle in the state?
1967.
67, excuse me.
Well, I'm going to give a brief answer and then give a longer answer later, okay? The brief answer is I don't think it was a boondoggle. I think it produced a very good Constitution, much better than the one we have now. To give you an example, a 5-person commission chaired by a judge to redistrict the legislature. Another example, the assumption of mandates on county government by the state incrementally over time. We could talk to, I have a list of, on a website, I have a list of 20 alternatives. So the document wasn't a bad document compared to the document we had before. The document failed at the polls because of the way it was offered to the voters was an all-or-nothing presentation. In 1938, the Constitutional Convention offered 10 propositions to the voters, and they adopted 8 of them, rejected 2 of them. Regarding the boondoggle and the membership, I'm going to talk a little bit about that as we move on, because I'm going to talk about how to staff the convention looking at the amending clause. So if you'll indulge me, and you find I'm not answering your question a little bit later, then I'll come back to it. Would that be all right?
Sure.
Okay. There's a gentleman over here. Say who you are, please.
Leo Kellogg. I've heard many times that the representatives in the convention are mostly legislators.
Right. Well, that's the boondoggle point.
Could you give some comments along the way as to the selection, and is there a way that that might be overcome in some respect?
Well,
And then along the way, I hope you would talk something about the possibilities of eliminating the gerrymandering and also the possibility of including initiative and recall.
okay. Well, the answer to the first thing is that, in fact, the exact numbers of legislators of sitting legislators and former legislators who are delegates can be found in Hank DeLay's book on the '67 convention, which was his doctoral dissertation. There were a lot of people from the government industry in the convention, judges, and I can't give you those numbers. I'm not prepared, but they're not. The convention is comprised of 3 delegates from every Senate district. So in the current Senate, there are 63 districts, so that would be 189 delegates, plus 15 elected at large, so 204 delegates. In the previous convention, there were fewer Senate districts, so the order of magnitude was about 197, if I have that right. Might have been 194. The legislators were a small minority of that number in the legislators and former legislators. However, they were defining of the ethos and character of the convention. A legislative leader became chair of the convention. Legislative rules were adopted for the convention. And certainly the constitutional requirement that delegates be compensated at the same level as assembly members meant that those people would be double compensated. Additionally, there were staff and judges and so on in the convention. So this is a matter of great concern, and I'm going to talk more about it. But there are ways, and I've been experiencing my 15 minutes of fame as we speak. So I've been in near dozen meetings already having this conversation, and people have ideas about how to address this. And I'll try to talk less about some of the detail and more about that as we go on, because there are some remedies. But let me put forward one fundamental point. The New York State, one reason to favor, and I know there are legislative advocates in the room, and I am surprised, as you may be surprised to know, I have advocated for the legislature as an institution in my career a lot. And I continue to do so in the face of the assault on the legislature of the federal prosecutor, which I think leads people to believe that somehow Praetorian government is better than democratic government. So I understand legislatures. However, I must say that the legislature as an institution and its members oppose a constitutional convention because they fear the consequences of the convention. And we are in a catch-22 situation with regard to addressing some of these problems, because some of them require constitutional amendment. And absent a convention, the only way to get an amendment is through the legislature, passing two separately elected bodies and with a popular referendum. So we've put forward, I personally and others have put forward amendments to address some of these problems, which have not surprisingly, have not moved through the legislature. So the argument then becomes, this is a flawed process because of double compensation, or a flawed process because who can get elected. We could get elected. You don't want that to happen, so reject the process. In other words, the people for whom the process was designed to bypass, so the structure of government can be reformed, are the very people situated to make you happier, some critics happier about the process. They won't do it, and then they'll argue against the process. So it's circular, and that's why I call it a catch-22. As I proceed through some of these slides, and I have no hope or expectation of getting through them all, I'll address some of these more specifically. Now, there are ways to deal with some of this, not all of this. Let me give you one example. If we elect delegates at a general election in an even-numbered year, which it turns out we would do, then legislators would have to stand for the legislature and for delegate in the same election. We could simply have a rule that would say that you can hold only one state-elected office. So if they succeeded in both elections, they would have to resign one position. Now, is this rule common in New York? Of course it's common in local government in New York. Dual office holding is very rarely permitted in New York government. So I'm sure that there might be a legal test, but I'm not sure, but I would be optimistic that such a dual office holding provision would be blocked. Now, some people would bar legislators from service. Now, obviously, this doesn't please legislators, right? So trying to advance the idea of a convention with legislators you're trying to keep outside the convention is problematic. Dual office holding provision is hard to fight against. Reminds me of a story of the presidential election of 1960, which I remember a little remotely. A guy was running for treasurer of Massachusetts, whose name was Kennedy, John Kennedy, and a guy was running for president, whose name was John Kennedy. And a woman was interviewed at an exit interview in a poll, and she was asked, what does she think of that? And she said, if he wants both jobs, he can have both jobs. I think that the general public would be skeptical about opposition to a dual office holding provision, which has the effect of addressing some of the questions without barring somebody on the basis of profession, which I think is constitutionally suspect. But let me get back to my, so I actually partially answered you. I'm not sure I satisfied you, but I didn't delay the answer.
No, let's address it.
Okay. Now, every provision is theoretically subject to change. The cost-benefit calculation, as I pointed out to people when they think about that, they often come out risk-adverse. You know, like people who are investing their pension money, you know, as they get older, risk-adverse, describing myself. Now remember, there are three votes involved here. I call the constitutional process a belt and suspenders process because there are three votes. There's a vote to hold the convention, yes or no. There's a vote to elect the delegates, and there's a vote to accept or not accept the outcome. So it's a very difficult process for achieving change. That's one of the reasons I call it a blunt instrument. But it's the only instrument we have. You know, that's the fundamental point. This is the provision, and I don't expect you to be able to read this, but I put in bold text the constitutional elements that are controversial or significant, and I'm going to quickly go through them, so you can go back and we can post this for you, and you can have it and look at it and so on. But one thing to remember is that this is very complex. The reason it's complex is that something you all know about from being professionals in government, that your remedy for a problem is almost certainly going to create a new problem that you never thought of. And so the 1894 convention was fixing a problem. The problem was that the Constitutional Convention was authorized but never held because the Democrats and Republicans, one holding the governorship and the other holding the legislature, couldn't agree on the rules of how to elect delegates and how to convene the body and so on. So when the convention convened, they said, we're going to fix that. We're going to put all in the Constitution. Then the legislature won't be able to screw it up in the future. So that's what we have. We have an 1894 remedy that creates problems in the 21st century. A convention is called if a majority obtained on the question. Now, this is an easier standard than in Hawaii and Maryland, where a majority of those turning up to vote has to be achieved to call a convention. So we have a lesser threshold for calling convention. Actually, the Maryland outcome produced a majority on the question, but not a majority of those who turned out to vote in their most recent vote, and it was litigated, and the advocates for a convention failed. Delegate election would occur in 2016, in a presidential year with higher turnout and a Democrat bias. This is something that opponents to a convention who are liberals in their politics overlook, that the context for selecting delegates would be, in New York, would be pro-Democrat, because presidential elections turn out more New York voters who only turn out in presidential elections, and those additional voters are much more highly likely to be Democratic partisans than Republican partisans, who turn out more consistently but are far fewer in number. 3 delegates are selected from each Senate district. This is thought to be a Republican bias because the Senate districts are gerrymandered to produce Republican state senators. However, even a casual attention would remind you that recently these districts have produced a Democrat majority in the Senate. Unfortunately, the Democrats have shown little capacity to organize the Senate, but they actually whether you regard it as unfortunate or not, let me return to that, is your own point of view. Some are inclined to think it is fortunate, but the fact of the matter is that Democrat majority has been produced, so the districts are not presumptively Republican. 15 delegates selected at large, vacancies filled by remaining district or at-large delegates. That's actually the vacancy filling provision is the only state that has a vacancy filling provision in its constitution for the convention. Yes?
Yeah, if the election to determine whether or not my name's Tony Cantori, by the way.
Right.
If the election to determine whether or not there's going to be a constitutional convention is held in November of 2017.
This should be 2018.
Okay,
That's a typographical error.
but that's not a presidential year.
No, so it would be a gubernatorial year. It would still be a Democrat advantage.
Right.
So that's a massive mistake by the presenter. I will point out that Mr. Cantori went to St. Lawrence University and had the same teachers as I had. So,
Pay better attention.
right. He took better courses. I took easier courses than he took. I'm sorry for the mistake, and the analysis is substantially correct, although to a lesser degree. Because the turnout in gubernatorial years is still Democratic bias, but less than presidential years. Now, once we authorize a convention, litigation is almost certain, because the delegate selection process will be regarded as flawed. I'm so upset by that mistake. Must be aging. Delegate selection process, every time something goes wrong and you're 70 years old, you think it's because you're getting older, right? But it's not. It's just because you're not paying attention sometimes. Anyway, the delegate selection process will be challenged because we're using multi-member districts to choose delegates, which is a red flag under the Voting Rights Act. Now, the Voting Rights Act has been changed, but litigation is still possible under the Voting Rights Act. And almost immediately, advocates for minority groups would challenge the at-large election of delegates and the delegate selection from three-person districts. That's a good thing. It's a good thing because it'll drive attention to the process, to those elements of the process that can be affected by statute. And it's a good thing because the convention will have to be held on time because it's constitutionally prescribed to hold it on time. And if there's a failure of legislative action, then a judge, probably a federal judge, will be addressing the problem and seeking remedies. And we see in our redistricting experience that the engagement of federal judges focuses the mind of this New York State legislature. They have to decide whether to let the matter rest with the judge or whether to take up the matter. In either case, we'll have some of the process questions addressed, those that can be addressed by statute, that would otherwise remain unaddressed because of the litigation. But the litigation has to be anticipated, and certainly the process for electing delegates will attract litigation. Yes.
Steve Elliott. In the past, the voting rights litigation has been under the pre-clearance provisions for the most part, and presumably we won't have that this time around, so it'd have to be a Section 2.
Right.
And it'll take longer and be a different process.
Right.
Just wanted to point that out.
But the evidentiary base would be similarly, the evidentiary requirements would be similar. They'd still have to prove that the way the election is structured would deny minorities effective choice.
Right.
And they'd have to come up with behavioral information to show that the minorities voted as a block, that their choice was systematically diminished. I talked to Richard Berfault about this, an attorney who knows a lot about New York government, and the evidentiary challenges in litigation would be substantial because we don't hold those sorts of elections, multi-member elections from these districts a lot, so we don't have a lot of direct experience. We have indirect experience, so it would be challenging. A lot of room for potential experts at high fees, I'm pleased to say. Yeah. The way the choices are presented to the electorate would be significant. So those of you who may remember this, we used tickets, Democrat and Republican tickets for this. By the way, there's less question about the statewide election as long as the Senate district-based elections are addressed, more likelihood, according to attorneys that we hired in the 90s, that we could sustain that because it was statewide, then we could sustain multi-member districts Senate districts used as multi-member districts. But it would be, the whole thing would be litigated, there's no question. 15 at large, we used party tickets. Making exceptions was very difficult. Now we can we can specify. We proposed in '97 that we give each voter one vote rather than 3 votes to elect delegates within the Senate district, and the effect of that would give minorities much greater chance of getting the mathematical consequence of getting a preferred outcome among the 3 elected delegates. There would be greater diversity in the delegation. There would also be less chance that a party ticket defined by party leaders would be fully returned if we had 1 vote for each voter with 3 elected. We also have using a different technology for electing delegates, so that allows greater range of choice for voters. It would be easier to select individuals to be in the statewide delegation than it was in the past, which required pasting stickers on parts of the machine and so on. So this opens up the question of whether we want that range of choice, how would we present it on the new technology. Election rules, generally the general election law prevails. We could do specific statutory requirements and since this is statutory, not constitutionally defined, we could create different rules for nomination and make it much easier to access the ballot. encourage the kind of candidacies that would make the election more competitive in districts with a different voting system. We could do different campaign finance arrangements, arguing that we could try things out without changing the fundamental structure of state government by testing them in this environment. We could even have a challenge whether the vote would be partisan. Whether we could get that legislation like this through the state legislature is very problematic, but the options are opened up, and the litigation drives the choices in a different way than would be ordinarily the case, potentially, not actually, but potentially. I talked about the misunderstood, what I think is a misunderstood legacy of 1967. I talked about double dipping, the government industry dominating. Some would argue that it's not a bad thing that people with experience in government go to a constitutional convention. The analogy, inapt analogy I hear is barring surgeons from the operating room. You know, not quite a perfect analogy. Dual office holding prohibition I've talked about. Some places suggest doing nothing as the problem of barring people. One thing legislators have done is introduce constitutional amendments or statutes that bar whole classes of people from service, you know, people who are employed by the government, people who are lobbyists, people who are legislators. Their answer to trying to bar legislators is to think about a lot of other people who if you're going to leave me out, well, let's leave out everybody else. Let's leave out professors of political science, you know. That's facetious, but if you look at the draft legislation that's been entered in the last several years, you'll see that. Time, place, and process. The convention will convene, I think I have this one right, in 2019 in the Capitol. Well, this was written in a time where the legislature was out of the Capitol by late February, early March. So we'd have these two groups, and we saw what happens when two groups want to control one of the chambers. So they'd have to work it out. Somebody would have to meet in the egg, and somebody would have to meet in the Capitol. Or the legislature could adjourn. The duration is as needed, usually not more than 3 or 4 months, usually would be expected. Resources are authorized in the Constitution. The convention selects its own leadership, adopts its own rules. Majority of those elected are needed to make any change. Those elected, not those present. Ratification. Can't be offered for ratification until 6 weeks has passed from the convention making its closing and making its recommendations. Majority of those voting on the question would determine the outcome. The time of offering the question is at the discretion of the legislature. It could be at a general election, could be at a special election. The character of the questions could be are at the discretion of the convention. So when I worked on the New York City Charter, some of you may remember we changed the New York City Charter a lot in the 80s, in the late 80s. When I worked on that, we offered 6 questions. Our idea was we'd separate out some of the really politically charged elements. I remember designating buildings as historic was one of them because there was a big fight between the real estate industry and the historic preservation community. And it turned out that all 6 questions were passed. So there was no, the argument for one question is that it's an integral document. The argument for more than one question is that you take some of the controversial matters out and preserve the fundamentals of the changes and give people a chance to oppose those they regard as less fundamental.
Jerry, I have a quick question for you, I think. Paul Schatz off SAPA. The question is this. 20 years ago, you mentioned technology briefly up there, but 20 years ago we didn't have social media. And we had Steve Greenberg at one of our candid conversations, I think it was about a year ago.
Right.
He talked about the difficulty of polling now because people can take their telephone numbers with them.
Right.
And so many people, especially younger people, don't even have landlines anymore, so it's
Right.
difficult to even get those phone numbers. So it's becoming very, very challenging to do that kind of polling. I have a daughter that lives in Washington. She still has a 518 area code on her phone. So to what extent do you think that social media might be a disruptive technology with respect to either the influencing the way people move, vote one way or the other, And how ugly could that get?
Well, I
to?
think in the referendum vote, social media will be fundamental. I've been, as I say, I've been around. There are people running for governor now who are very interested in this. The governor himself has said he favors a constitutional convention, but interestingly, he hasn't done anything about it. He hasn't prepared for it at all. So we have people seeing a potential political opportunity. If mobilization occurs, it's going to be a multi-million-dollar proposition, and the social media are going to be very fundamental to that. Now, you raised a question I haven't thought very hard about, which is when you convene a convention, what will social media, what attention will the media be giving to it? What difference will it make that the information environment is so different? I haven't thought about that. That's an intriguing question. And then I would say that on the approval process, social media would be fundamental. So, but all politics is transformed. This is just one, I often liken this to the College of Cardinals. You convene, and I'm a Jew, so I don't really get the College of Cardinals. But as far as I know, you convene this august body, and the Pope is found, selected, or recognized, whatever subtleties of language you want to use, and then you go away. In other words, the body has one purpose, and this is convening of a special body to do a special task, and then it goes away. So it's not supposed to have an institutional interest. It's supposed to have a single purpose. I also know from talking to former delegates that they feel that this is special, and this, by the way, is true of county charter commissions, city charter commissions to a lesser degree. People feel that they're dealing with fundamentals, and this affects their behavior. I don't think they get. If men were angels, no government would be necessary. Remember that great quotation from the Federalist Papers. I don't think people are turned into angels, but I do think they take very seriously the responsibility. So that has a dimension too. Now, is this essentially a corrupted and confounded institution in its fundamentals because of who's likely to get elected? Well, that's one point of view, and that's a point of view for doing nothing. And I guess you have to weigh doing nothing against your notion about what the degree of the nature of the problem. If the problem is fundamental, and there are better ways to govern New York and do districting, finance elections. One of my bête noirs is bête noirs subject to plural? Bête noir is French. Well, one of the things that upsets me is that we have our election administration process in our Constitution. So our so-called bipartisan election administration, which is essentially a collusion between two of the major parties in managing the election and controlling access to public office, is constitutionally grounded. And we can do better. We can do this. We have neutral civil servants who do very hard work. We can do this better. So I would change, that would be a fundamental change in who gets into office, how access to office occurs, and so on, from such an event. So we have to decide how bad things are and whether we wish to roll the dice. And my view is, now we're talking about my view. My view is that risk-benefit, it's worth taking the risk because the risks that are calculated aren't real risks a lot of the time. I don't think that anybody's going to remove Forever Wild from the New York Constitution and expect the document to be passed at referendum. So some things that are seen as risks aren't risks, and the benefits are potentially palpable. And if bad things are done, there's a checkpoint. The referendum process. So that's my. In the interest of time, I don't know what you all are expecting of me or of yourselves, but it's a little after 1 o'clock. I have the effective date, and then I have some details about the nature of the Constitution and the critiques of the Constitution that I could talk about, but I'd be happy to stop if you want me to stop.
Well, we're still good on time, depending on discussion and questions. But
So
we're scheduled to go until 1:30.
Okay, so I'm going to proceed. Okay, coming back to the one of the initial points that I made, the national constitution is not the same as state constitutions. If you think about it, there were state constitutions in place when the national constitution was adopted. And as people who've run organizations or been important in making laws, the first thing you ask is, what's already there? I'm going to write this law or regulation relative to what the body of law or regulation is that's in place. I'm going to decide what parts of the things that are in place I want to take out, decide what I want to put in, decide how to reorder this information. So we have in this country a constitutional system. One element of it is the national constitution. And the people who wrote the national constitution knew that those state constitutions existed, and they knew what was in them. Now, of course, they didn't have 50 state constitutions, and the state constitutions have evolved and changed fundamentally. But this idea of constitutional system is an interesting idea to carry around in your head because it suggests that the function of the national document might be different than the state documents which were already there in the first place. I'm going to talk a little about that in the next few minutes. Now, there's a difference between practical reality and historic development and empirical and theory, and I hope to be able to make those distinctions. But this is an important, one example. Eligibility to vote is not addressed in the U.S. Constitution. It's addressed by the states. So this with the exception of the now very offensive 3/5 rule and so on, in terms of this calculation of representation. So stuff didn't get done because it was easy to leave it to the states and let them each do it so they wouldn't disagree about it and you could get the outcome. It's a political calculation. Is the state constitution too long, or is it long for good reasons? Now, this has a typographical error in it, I noticed. The national constitution is established a limited government. The state constitution limits an established government. What does that mean? Well, the revolutionary transference of sovereignty was from the king to the states. So now we have these states that are presumably plenary, and you got to say, well, what can't they do? How should they be organized, and what can't they do? The national government was formed to be limited. So fundamentally different. That's one of the reasons the state constitution is longer, because limiting an established government, you get into the weeds to do that. You get into the weeds to do that. So the national constitution specifies what the government may do, we have, of course, the necessary and proper clause, which is, the barn door that has allowed the national government to grow substantially without changing the text. And the state constitution is very worried about what the state government may not do. That's not all it does, and I'll get to a list in a minute. Many state constitutions are Baroque collections of essentially statutory material. That's Judge Wilkinson. Some of you may know him. He's a quite conservative but very well-known federal judge who's been considered for the U.S. Supreme Court several times. Now, the average state constitution in 2009, when I last checked, was 26,721 words. This is one reason to have a word processor. You can get this number without counting. New York's Constitution is the 11th longest with 51,700 words. And the U.S. Constitution is a little over 8,000 words, including the amendments. The state constitutions, according to one count, state constitutions had 828 provisions. New York, on average, the New York Constitution had 1,093. Now, what you count as a provision is a methodological question. So this is illustrative, not definitive. But it suggests the conventional attack on the state constitution. It's too long, too detailed, too many provisions. But when we think about function, we would expect it to be longer and more detailed than the national constitution because it's functionally different. So the question is it longer for a good reason, or is it longer for a bad reason in some dimensions? So Peter Gailey, and some of you have heard of Peter Gailey. Does anybody know Peter? The preeminent scholar of the history of the New York Constitution, preeminent living scholar. with a guy named Chris Bopst, who was his student at Canisius College in Buffalo, went through the Constitution and determined dead letter law. And we, for example, if you look at and you know a lot about this, if you look at the redistricting provisions, there are a lot of elements of those provisions that are unconstitutional under federal constitutional determination, but have been left in the document. So if you go through the Constitution and just take out dead letter law without touching any function, you would reduce its size significantly. And he has an essay on that in the Albany Law Review, and we'll have that in our book when we publish that book.
Quick question.
Yes.
Do you know if the U.S. Constitution is shorter in words than all state constitutions?
It is. It is. I'm almost certain. I would have to check, but I'm almost certain it is. Chris Hammonds wrote an article about state constitutions in 1999 in the American Political Science Review, and this was very comforting to me because almost everything in there is has a statistical analysis that defies my understanding, but I could actually read this essay. So it showed that my part of the profession is still attended to by the principal journal, but that was 15 years ago. And he raises the question about length, and New York's Constitution is typical in about a third of its provisions are devoted to statutory matters. Now, what happens is that certain political interests are powerful at a particular moment in history and are able to put into the document things that protect or advance their values or protect their interests. So some of the matters that we discussed. So the Forever Wild provision, if you read the history of that, very interesting. The logging interests in New York were very powerful, and there was great fear about the denuding New York forests, and that occurred in many parts of New York. And that provision was entered into the Constitution to reinforce constraints beyond the reach of the legislature on that interest. The legislature couldn't easily change the Constitution. And if you read the politics of that time, you'll find extraordinary battles around this question. This was not a settled question when the constitutional provision was entered. Another one that I've written about is gambling. You know, it may surprise you, but there's actually a provision prohibiting gambling in the New York Constitution. And by the way, the lack of convergence between law and practice is very discouraging to citizens because it reinforces their predisposition to believe that law doesn't matter. And that's a very important reason to pay attention to some of these matters, which seem to be arcane or remote. Well, the gambling prohibitions rise from 19th century politics and have been systematically attenuated in the last 125 years, and I've written about that. And it's interesting to compare the gambling provisions and the environmental provisions. The environmental provisions have become reinforced and the gambling provisions have become attenuated. What's the difference? Well, the difference is that the context has changed. You know, the society is more accepting of gambling than it was, but it's less accepting of damage to the environment. So the contemporary politics is significant in reinforcing or diminishing certain constitutional values. And that's a very important thing to think about when you're thinking about a constitutional convention. What are the values in the frame of the calling of the convention? You know, what are the social values? In 1938, we put in some of the most advanced affirmative rights positive rights for the poor in the United States, which still remain in the New York Constitution. Those were the values of the day. So if you think New York is being dominated by values offensive to you and your points of view, you should not support a convention. But if you think the convention offers an opportunity for you to reinforce those values that may be at risk, then you would be for a convention. So some people think of a convention as anathema because we put gun rights in the Constitution. Other people think it's anathema because we've put choice rights in the Constitution. What values are dominant? What context and constraint and values would be brought to a convention by people in New York elected to serve? That's a fundamental question, and that is part of the risk-benefit calculation. Now I have 9 substantive aspects of constitutions in my list. Some people have 4, some have 5. That's probably not no correct list. I use this as a way of saying, what would the issues be? So if you took at the question of recall of elected officials or the initiative, specifying government processes, empowering or constraining institutions, that's what you're doing. You're defining an institutional alternative that would be constraining or bypassing the legislature, or bringing into a way of bringing into accountable certain elected officials that we know sometimes is used in California to recall the governor, for example. It's a very famous example, more commonly used to recall judges, which concerns me, actually. So why do we have this Constitution? What institutional structures should we have? How would we staff them? That is, what rules for defining districts and holding elections? How are they empowered? What can they do? How do they do it? We have a process called a provision in our Constitution that requires a bill to sit on the legislators' desks for 3 days before they're acting. And we also have a process for bypassing that on gubernatorial initiative. It's commonly bypassed outside of emergencies. The matter's been litigated, and one of my most admired New Yorkers, Chief Judge Kaye, said in her opinion on that matter, essentially, and I can paraphrase, this is so entrenched that we can't touch it. You know, so she's saying that the Constitution doesn't mean what it says. You know, and what does the combination of these dimensions mean? It means that the governor is more powerful in legislating than we intended. Now, do we want that to say, ho-hum, that's the way it ought to be, that's the way things work out, governors always get their way? Or do we want to reconsider the balance in our separation of power system based on our experience and the incapacity, the lack of capacity or will in our courts, maybe for good reason, but she's afraid of all the laws being undone that were passed under message of necessity, maybe for good reason, but unwilling to touch the matter. Mandating government, so positive rights, education, for example, a very famous example, the attention to the needs of the poor, another famous example. Directives, do this. Some of our provisions are not directives, they're guides, others are directives. I ask my students to think about the difference between the word shall and the word may. Limits upon government, relationships with other governments, that has to do with the famous question of home rule. When you go down to New York City and talk about the Constitution, all they want to talk about is home rule. Somehow, everything will be okay if the city is liberated from the state's clutches. Much of New York City politics is New York City politicians in Albany fighting New York City politicians in New York City for control of New York City. The history of home rule is interesting, and I haven't got time for it now, but certainly there are fair issues. The home rule provision in the Constitution is mischievous. You want to reform the structures of government, by the way, the numbers of government, which the governor cares about. But we do know that there are issues of state imposition upon localities that may be addressed through redefinition of the home rule provision in the Constitution. And so it's kind of interesting, and this is a personal comment. I was born in Brooklyn, raised in Queens, went to school upstate, and went to work upstate. And my wife was born in Manhattan and went to school in Manhattan and came upstate, raised a family. The minute she could, I should have known when I married her, when she said, I said, why do you go to New York all the time? It seems you have nothing to do there. She says, I have to feel the sidewalk beneath my feet. So she went home to New York. She works down in New York now, and she thinks this is very romantic. I've come around to the view that it's okay, but it's taken a while. But the point is that I've become an upstater. So when I go down to the city, and she hasn't, and some people who come upstate are converted to being upstaters, and some are in exile, and when I go down to the city and give these talks, I look askance at the lack of understanding of our complex local government system and how we do things in the counties and how we do things in our towns and villages. I love Governor Patterson very much. I think he's a very decent guy. But I remember reporting a state commission's outcomes to him, and he was puzzled because he just doesn't, his life and experience didn't require him to pay attention. So the home rule provision is more than New York City's relationship to New York State. But there is a big opportunity in that for upstate New York, I think, local government. and are changed processes. In other words, we've entrenched processes in the Constitution we might want to reconsider after a century and a quarter. So I'm not going to talk to you about specific issues, but this list captures whatever issue you have in mind that's important to you, or any risk you have in mind that's important to you, is captured by this in these categories, I think. So you could think about it that way. And then substantive areas and issues, I left the slide blank because I thought you might want to fill it in. Okay, so thank you for your attention. I'll take any further questions. Thank you. Yes, Bob.
Have you hired Richard Berfault?
I can't afford Richard Berfault, but I call him up and ask him questions, and he doesn't charge me. He's brilliant, brilliant. And if anybody cares about local government in New York, they should read his law review articles in the Columbia Law Review. For when he got his tenure, he wrote 2 magnificent articles on local government in New York. So I recommend them. And many others, but those 2 are magnificent. Well, thank you very much.
Thank you, Jerry.
So this was the beginning of a process of education. Of course, as we get closer to a referendum vote, various groups and their lobbyists are going to be advocating for or against, and of course it will get very issue specific. And part of what Rockefeller Institute and the coalition is going to do, I'm sure, Bob, going forward, is to help the public and certainly help people like us cut through some of that and be able to discern what the real implications of a constitutional convention are likely to be. And Professor Benjamin certainly started that conversation today. So I want to again thank Rockefeller Institute and Dr. Benjamin for what you are doing, because I'm one of those people that thinks basically the electorate is pretty dumb about issues and really can't understand the substance of it. And so after the TV commercials are gone and the radio commercials, and of course when I ask the social media question, what happens now is that within the convention, are there going to be ground rules prohibiting people from tweeting or posting what's going on in order to marshal forces against an issue that might be likely to be included? So those are the kinds of dynamics, I think, that we just don't know at this point what's going to happen. And so again, thank you all. This now concludes this candid conversation.